the first to know Nsem-Pii TV.
Nanyoma bebre ena ekoso ewo the Financial and Economic Crime Division of the Accra High Court. And a cross-examination also. Day 2 of the cross-examination between the state and the third accused, Dejected Jakpa. And that day, the 68 WhatsApp messages tendered in as evidence by the Attorney General. Justice Efiasewa Sarebutwi Eso Muse Twitwe using various rules and regulations which governs Ghana Yamamra Constitution. And ne in fact, Dejected Jakpa ke kan sembi wo courtwa ema Justice Efiasewa Sarebutwi ono ankasa ne lawyers and the nipa represented the Attorney General Yamami Ivan Atakro Bobisa and the Deputy Attorney General Alfred Tuya Yeboah ehudiri wo mo say we declared war on the Attorney General. Sa statement na statement na emu oduye se betumi apie de free an accused person ano e court. But Dejected Jakpa be na no kan sa asemi. Enyama ekoso court nyina no, our cameras were still outside the court premises near here the bekoso. We are friend of Nsem-Pii TV VAR. Interestingly, mame Emma security. Emra na Dejected Jakpa undergo cross-examination by no akasa ne lawyer. Ye no mu yi. Court to point ye no a obehunu say Dejected Jakpa. Lawyer Tadio sorry. Eduzita Mako. Abraham Amaleba. Afe Sami Jamfi. Felix Ofosu Kwache. Kesi Lato Forcing. And afe minority in parliament. No mu nyina bomu apie. Ompie ba ye no ano. Obehunu say the NDC rented media houses amount to omo cameras ready for press conference. Na propaganda ni gum je se dun ketia de ne de na mbole. Sami Jamfi de ne de na mbamboy. Na Ofosu Kwache de free yape. Na Abraham Amaleba de free gushegu no omo kabo musa. Now Emra tables no turning ya cross examination abeye between the state and Dejected Jakpa. And then they two ikra de ade si na enwa. Interestingly, Emre bia no omo yes our press conference no omo ke cancel because e come awon no. Dejected Jakpa kwatra kan mu a na o spray cash e de go NDC supporters ya omo twa ne kan ho ahia. Enne cross examination kwa wie yem. Dejected Jakpa nko a e de pie free court. Ye hunu ato forcing. Ye hunu Sami Jamfi. Ye hunu Abraham Amaleba. E kire yansan ye hunu se Felix Ofosu Kwache e betran Dejected Jakpa kai. Now, as resema wo ho ne say, as usual, NDC supporters be bo chenku e do for Dejected Jakpa kan ho expecting senka said the be oye no no obetu ska kakregu. Dejected Jakpa be na no ka say dear, I am fighting for my life. I am fighting for my freedom. Sa ekumienu ya me kun, it is more expensive than sika mo rent me ni kapre. Sa de petrol e ka che obuboni no otigate na no sika de jete de ni bi. Na so Yesu dim sore na ntere. Dejected Jakpa sika de jete de sese me ni bi o because I am fighting for my freedom. I am fighting for my life. Enya sem ketwa. Press conference ya twen bibi asa amaso. It shows how the NDC minority leadership in parliament say they are going to solidarize with Ato Forcing. And then who minority of parliament who be a court. Now Dejected Jakpa has been left to his fate. The young one say or to say he is fighting for his freedom, he is fighting for his life. You make a video no. Here we are, come on, dear children. They are tossed.
If my brother is suffer for the boxes are you to need money. Don't give him more money.
We are fighting for my liberty. Then you want to make money from
no man them. Oh,
what I'm saying, you don't understand me. I am fighting for my liberty. It's expensive. Now you want to make money from me again.
We take prayer, follow him so that the thing will come down.
Objected to that evidence, and so today the trial judge had to make a ruling which she did, and gave reasons why she admitted that into evidence, that for the interest of reciprocity and the fact that a portion of this WhatsApp chat had already been tendered into evidence by Richard Jakpa himself. And on the day it was being tendered into evidence, Richard Jakpa had told the court that this is not the full WhatsApp chat, but what I'm presenting to the court is what is relevant to the ongoing case.
Okay.
Based on those two instances, the judge deemed it fit and right to admit
more like
into
saying
evidence.
This could be the full chat that he himself alluded to earlier.
Exactly.
And so this has to be accepted. Well, the prosecution, what was that the focus of the prosecution on the 68 chat Richard Jakpa is said to have had or sent to Godfrey Yeboah-Dame?
So that was essentially the focus of prosecution today. Delve deep into the WhatsApp chat between Godfrey Yeboah-Dame and Richard Jakpa. The AG sought to make the point that Godfrey Yeboah-Dame and Richard Jakpa, or Godfrey Yeboah-Dame himself, never arranged for a meeting between himself and Richard Jakpa. And that claims by Richard Jakpa that Godfrey Yeboah-Dame arranged that meeting between himself and Jakpa at the residence of Jakpa's cousin, that is the Supreme Court judge, it's not true. And that Richard Jakpa only appeared, and those are the words of the prosecution, that Richard Jakpa only appeared at his cousin's residence and met the Attorney General there. Richard Jakpa says that is not true.
Okay.
It was an arranged meeting, and his cousin was the one who called him that the Attorney General says he has a meeting with him at his residence and called him to come, and he honored that invitation by the Attorney General.
So what really prompted his declaration of war on the AG?
Yeah, so if you recall, Richard Jakpa, this is not the first time he said it in open court, had said that the Attorney General Godfrey Yeboah-Dame had promised him that when it gets to the stage of no case submission, he would let Richard Jakpa walk as a free man. The AG, according to Richard Jakpa, betrayed him. So, and that was before they met at his cousin's residence. And that was why when they met at Unikolindi's house, he got angry at the Attorney General and told him that you promised me. We had a deal. I had given you documents. And he spoke to those documents he had sent on WhatsApp to the Attorney General, which today prosecution said the Attorney General didn't use it anyway. Those
because
documents,
the Attorney General filed those documents
prior
to
Jakpa sending it. And Jakpa's defense is that, well, I had sent it. The Attorney General requested for it. He also requests for other documents which I had sent. It is up to him to use which documents he preferred. It doesn't negate the fact that I sent him documents and he received those documents.
It's quite interesting in that process. He also mentioned Trojan horse, that some of the documents he sent in as a Trojan horse.
Exactly. So all those documents he sent to the Attorney General, according to Richard Jakpa, is like a Trojan horse because he knew in dealing with, that is, I'm going to say what exactly Richard Jakpa said. That in his dealings with the members of this current administration, he knows that they do not honor their words. And so he sent those documents so he could testify in court today and make reference to them that indeed he sent documents to the Attorney General.
What did the AG's department say in relation to that declaration?
Well, so according to Tia Yeboah, who is the Deputy Attorney General, he says this declaration of war by Richard Jakpa is rather unfortunate, and they are going to take the necessary steps to make sure that the Attorney General himself and maybe the rest of the department stay safe. Tell us about the proceedings today, your initial reaction.
Oh, today that has been a chapter 2, isn't it? Tuesday was chapter 1, today chapter 2. You witnessed it. You heard matters. You make your own judgment out of what you heard. You heard issues about someone operating in the underworld and someone using his legal skills, declaration of war against the Attorney General. All this came up. So, interesting proceedings.
What do you make of the fact that the Attorney General rejected an appeal he made to him to make him a witness when he said you couldn't get him something he had requested for?
That is the prerogative of Attorney General, and we use witnesses that we think will further our cause. There was no decision to use him as a witness. The only decision was to use a witness that we have penciled to call. And so I think it was of no moment to us. Use him as a witness.
But with the nature
You were in court. We showed some documents to him just to ensure that he answers certain questions. I think the proceeding for today has met our expectations. We tendered what we had on our phone, 100%. If he has others, he knows what to do because he's still in the box.
What do you also make that he make the point that there was never a plea bargain discussion between himself and the Attorney General?
We'll get there. They are documentary. We'll get there. Today we'll go to a certain point. So come to the chapter 3 and you hear all those things.
And how are the claim that he has entered the war on Attorney General?
I think it's quite unfortunate, to be frank with you, because that direction of war, according to him, whether he is acquitted or whether he's convicted, is declared that war. So he has put us on notice. And so the needed steps will be taken.
If indeed he said it to the Attorney General at his cousin's house, he should be aware of that already, not in open court.
AG has not admitted such a thing. And so now that we've heard it in open court, you will take the necessary steps.
As in security-wise for the Attorney General?
We'll take the necessary steps.
What would that step entail?
That step, when we take it, you'll get to know it.
That is the Deputy AG. I mean, in court, we understand Felix Ofosu-Kwakye also spoke on behalf of the first and third accused. What did he say?
Yeah, so according to Felix Kwakye Ofosu, though we see Richard Jakpa in the witness box, it is the character of the Attorney General that is on trial.
The AG attempted to douse the potency of Mr. Jakpa's testimony, but he stuck to his guns. He repeated some of the things that he has said before that you in court have observed. He insisted that his initial contact with the AG was limited to explaining his side of the story to him because he believed that the AG was not fully aware of the facts and therefore may have been mistaken in adding him to the people that were being prosecuted. So he thought that an engagement with the AG, at which engagement he had the opportunity to spell out the full facts and furnish the AG with supplementary documents, was going to lead to the conclusion that perhaps he had no case to answer. That engagement quickly mothballed into an effort by the AG to conduct himself unethically and urge Mr. Jakpa to do things that were unethical. Indeed, Mr. Jakpa disclosed that it was the AG's responsibility as the chief law enforcement officer of the Republic to know that an engagement with a represented accused person on the blind side of his lawyers was unethical.
How damaging would you say it would be for Mr. Jakpa having said in open court that he had declared war on the Attorney General? How damaging would that be for his case going forward? These are serious issues.
We get the sense that the Attorney General wants to say that Mr. Jakpa is doing this in retribution for what he believed to be the Attorney General's failure to keep his part of the bargain. But the point is that Mr. Jakpa insisted that he has not said anything that hasn't happened. If I have discussions with you and we agree that you will do something and you fail to do it, and I come out to say that we agreed that we will do this and didn't do it, I have not said anything that is not true. If it were the case that Mr. Jakpa was saying things that have been proven to be untrue by the court, then you could say that some damage has been done to his reputation. But as of now, as far as he's concerned, he has not said anything that did not happen.
So that's Felix Ofosu-Kwakye there. Let's bring in a private legal practitioner, Samson Ladi-Ayanini, who joins us on the telephone lines. Now, grateful to you, Samson, for joining. First off, what's your own interpretation of what happened in court today?
As we indicated the last time, our law that governs the admissibility or non-admissibility of evidence, the Evidence Act, is very clear that evidence that is relevant is admissible, particularly in Section 51. So they have been able to make the point about the fact that this is a relevant evidence, the WhatsApp conversations, and have succeeded in getting it admitted. I would have been surprised to confess to you that it would not have been admitted because the evidence of the accused person about the recording, the secret tape has been admitted. And therefore, I think it would be too much for anybody to have expected that the judge will not admit this as well. And as we discussed the last time, the law talks about how, character can be impugned to affect the credibility of a witness under qualified circumstances in the law. So evidence of good character can be used to support the credibility of a witness. And the other way is also possible under qualified terms, except that the law would require that you would have put that into the evidence already before you can speak to it in trying to either affirm the good character of the person or damage the bad character of the person somewhat. So I think it's good for them that it's been admitted, just as it's good for the accused that theirs was also admitted the last time.
But there's also the issue about the weight that could be placed on these sort of evidence.
Yes, that's the job of the judge. The judge will now evaluate the evidence and come to a finding of fact. All the talking and some of it quite irrelevant noise in the media will not matter as far as evaluating the evidence is concerned in the courtroom. But you and I cannot attempt to do that on radio for a matter that is ongoing because of the law's prohibitions, including the potential of contempt. So that is the province of the judge. But after everything has come to an end, the judge will then retire in looking at how to come to the judgment, make a decision whether this WhatsApp, chat that you have submitted and have used it for your cross-examination purposes, to what extent does it serve the purpose you put it in? This state that you brought into the court as evidence, to what extent does it support your case or negate the existence of a fact, and so on? To what extent does it impugn something that the prosecution intends to do, which must go or inure to your favor? All of that will be in the province of the judge to make.
Now, for purposes of education, how will the tape and WhatsApp chats, which have been presented in court, help this case, since the main issue is about someone causing financial loss to the state?
So, criminal trials, the burden to discharge is proof beyond reasonable doubt of the allegations or charges made against the accused person. By law, if there is a small doubt, it is supposed to lead or inure to the benefit of the accused person and potentially go into leading to their acquittal or discharge, so to speak. So, to the extent that they are seeking to use this to suggest the things they are saying, that somebody suggested that you were not the target or that you had done nothing wrong and so on and so forth, at the risk of seeking to get into the merit of the matter, this is the kind of thing that is going to happen. And the judge will have to make that assessment. I don't think it is right for anybody to seek to dismiss that these things are not important. They are important.
Now, some also say the admission of the tape and WhatsApp chat between the two, that's the AG and Richard Jakpa, is probably turning the case